Okay, so let's talk about liability for an agent's negligence. Now, under the doctrine of respondent superior, a principal employer is liable for any harm caused to a third party by an agent employed within the scope of employment. So keep in mind now, He-Man, principal, hires Leonardo, agent, all right? Under the doctrine of respondent superior, He-Man is going to be liable for the actions of Leonardo that are within the normal course of business or scope of employment. All right? So if He-Man hires Leonardo to be a bouncer and Leonardo, pushes someone out the door and they get hurt, he's liable. But if Leonardo, goes ninjutsu on him, drop kicks him over a Ferrari into a screen, and beats him to death with his katana, that's outside the scope. The job of a bouncer is to get people out of the bar, not to beat the ever-living fool out of them. Okay, so you see the difference? If it's within the normal course of business or the ordinary scope of employment, He-Man's liable. If it's outside of that, Leonardo's liable. Vicarious liability is liability without regard to the personal fault of the employer for torts committed by an employee in the scope of employment. Alright, so let's look at what we look at when we talk about scope of employment. Whether the employee's act was authorized by the employer. Certainly, Leonardo is authorized to escort people out of the bar. Okay? The time, place, and purpose of the act. Alright, we didn't really go into that, but that's going to be a factor. Whether the act was one commonly performed by employees on behalf of their employers. Is it common for a bouncer to escort someone out or to drop kick them over a Ferrari into a screen and then beat them to death or near death with a katana blade? No, that's not normal. The extent to which the employer's interest was in fact advanced by the act. Nearly killing someone did nothing for He-Man's bar. Extent to which the private interests of the employee were involved, whether the employer furnished the means by which an injury was inflicted, whether the employer had reason to know the employee would perform the act in question, and whether the employee had done it before, whether the act involved the commission of a serious crime. All right, so all of those things are factors we can look at when we are determining the scope of employment. Now, we also have this thing called a detour and a frolic. If a servant was on a frolic on his own and not in any way on his master's business, the master would not be liable. So, you're working for me. I send you to the courthouse to file a document, file a complaint. And along the way you're driving and there's a detour that makes you go around another building and to the courthouse. During the course of that you have a car accident. Are you on a detour or a frolic? You were on a detour. Okay? You were still doing my business. Whereas if you're driving and you notice a pretty pair of shoes in a window, you stop and you look at the shoes, you go inside, you try them on, and while you're in there you are involved in an altercation with another customer. That was more like a frolic. Okay? Nature of dangerous conditions. The employer is charged with knowledge of any dangerous condition discovered by the employee and pertinent to the employment satisfaction. So if an employee tells you something's going on, you're on notice. Borrowed servants. Employers sometimes lend the service of their employees to other employers. Liability. Most intentional torts that employees commit have no relation to their employment, thus their employers will not be liable. That's most of them. Liability for independent contractors' torts. An employer is not liable for physical harm caused to a third person by the negligent act of an independent contractor because they don't have any right or control over them. Liability for agents' crimes. An agent is liable for his or her own crimes. Right? How do we terminate an agency? Well, lapse of time. Certainly, you may have an agreement that says it's going to end on this date. Once that happens, it's done. Okay? Once the purpose is done, an agent can be employed to accomplish a particular objective. Okay? Occurrence of a specific event. Once an event occurs, it's over. Mutual agreement. Both parties can agree to go their separate ways. Option of one party. As a general rule, either party can terminate the agency relationship, but you can't have what we call a wrongful termination. This can subject the canceling party to a lawsuit for breach of contract, possibly. Agency coupled with an interest. The type of agency is not an agency in the usual sense because it's created for the agent's benefit instead of the principal's. Notice of termination. How do we do this? When the agent has been terminated by act of the parties, it is the principal's duty to inform any third parties who know the existence of the agency that has been terminated, because otherwise he may have apparent authority. Termination by operation of law. Certain things will cause agency to end. Death, insanity. Sure, once this happens, the agreement is terminated. Impossibility. When the specific subject matter of an agency is destroyed. Changed circumstances. When an event occurs that such an unusual effect on the subject matter of the agency that the agent can reasonably infer the principal will not want the agency to continue. Bankruptcy. If either party petitions for bankruptcy, the agency is usually terminated, or even war. When the principal's country or agent's country are at war with each other, the agency is terminated. So as you can see, there's a number of ways to actually terminate an agency.